Republicans like to tell us that the private sector can always do a better job than the government, and that's why we should privatize everything. The latest target of privatization is a judicial system where arbitrators are taking the place of our trial system, and I have Howard Nations with me to tell us this story. Howard Nations, how do you see this huge arbitration shift that's taken place in the U.S.? Chamber of Commerce, of course, making it happen. What's your take on it?
Well, Pap, this is just the latest in the unending series of attacks on trial by jury. Corporate America hates juries. They fear juries, and they do everything they can to avoid juries because it's only juries that can keep them in check for their fraudulent conduct and abuses of justice. Corporate America and the Chamber of Commerce buy politicians at every level and in every branch of government and in regulatory agencies. They block consumer legislation. They pass protective laws to protect corporations. What they can't buy are juries. So they devise ways to avoid them. Their companions in their exploits are two other jury haters, which are the Chamber of Commerce and Republican politicians. And this latest attack on juries by corporate America is forced arbitration, and combined with a class action ban to abolish consumer opportunity for redress in the courts for either corporate fraud or other corporate misdeeds.
Yeah, there's this article in New York Times, of course, it's Arbitration Everywhere, Stacking the Deck of Justice. There are multiple part series they're doing on this. And I'd like you to focus. It sounds like you're focusing on that article, and I'd like to continue focusing on it.
They did a great job on that.
They really did. It was just such it was almost like something you haven't seen from the New York Times for so long because they're so pro-corporate. I mean, but here, this is something to where, why is it that conservatives, they get so upset on this issue about the right to bear arms? What about the right to a jury trial? I mean, that is so basic part of our Constitution, and here you have courts, Republican courts, primarily Republican-appointed courts, that are taking that away and saying, no, we're going to allow arbitration to take place. Explain what arbitration really is, so people can understand how ridiculous this process is.
Well, corporations like American Express, Verizon, Goldman Sachs, Time Warner, they place mandatory arbitration clauses in your consumer contracts and in employment contracts, which eliminate the right to trial by jury for consumers and employees. It's in all that long list of fine print that you go to the bottom and you click agree. Well, you agree to give up your right to trial by jury. It applies to credit cards, car rentals, internet services, online shopping, use of cell phones, everything. They're just moving it across the board.
It really, where you see it was with fraud. Right. I mean, you see it where you're agreeing that if we defraud you, mom and pop, if we steal your pension program money and we know what we've done and you know it's wrong and we know it's criminal and we know the Justice Department won't do anything about it, now what you're left with in arbitration is appearing in front of our hand-picked shill, our corporate hand-picked shill, and letting that shill decide how much if you're entitled to get back from the money Goldman Sachs stole from you. Isn't that basically how this works?
That's exactly how it works, and they've got the arbitrators in their pockets, and you have no way to get around it. What the major thing they've been trying to do for years is do away with the class action lawsuits, because class action lawsuits are powerful tools for consumers and employees. It's their means of attacking predatory lending, wage theft, discrimination, and a plethora of other fraudulent business practices. And so what they've done is they have combined this arbitration clause with the ban on class actions. And it's done, very interestingly, a group of corporate attorneys are the ones that came up with this. And one of the corporate attorneys that filed one of the first lawsuits on this was a fellow by the name of John Roberts, who later became Chief Justice Roberts of the U.S. Supreme Court.
Who loves this idea.
Where he ruled on two Supreme Court decisions that upheld this arbitration, joined together with banning class actions. And in doing so, they disabled the consumer's ability to challenge all these various types of discrimination, and they overthrew decades and decades of consumer and employee protection laws.
Yeah, so here's how it works. Goldman Sachs or one of the Wall Street thieves steals from you. The way they steal is very sophisticated, but they steal from you, and they have a long history of stealing from people. So they steal from you, but it's not enough to where you could actually bring a lawsuit and go to battle with Goldman Sachs because it would be too expensive. Let's say they only stole $10,000 from you. Mm-hmm. So you can't, it's very tough to bring that individual $10,000 lawsuit. But when you bring a class, many people come together with the same lawsuit and the same claim, and then it's financially feasible to get everybody their money back. But the Supreme Court, under Roberts, as you point out, is trying to make it impossible to do that because the Republican hacks who put him there are asking him, demanding, ordering him to do that. And we all know John Roberts and Scalia and the rest of the folks that are now in the majority of that court are ordered around like pathetic dogs. So that's what's happened here, isn't it? I mean, that's the end of the story.
That is what's happened, and it goes to even smaller claims than that. For example, AT&T promised consumers that if you sign up with us, you'll get a telephone free. So then, what do? They bill them $30 for the phone. Well, no individual is going to take on AT&T for $30. But if you got 1 million individuals they've done that to, you got a $30 million claim. That's a class action. That's a different story. They have to respond to that. But by doing away with that class action, all those people that got defrauded out of $30 each, they have no place to go really, because you can't go to arbitration for $30.
So it shuts everything down, basically.
Shuts it down completely.
And if you act, here's what people don't understand. Let's assume you do have a claim that's big enough to where somebody can actually take a risk on it to actually bring a case. When you go to arbitration, what they do is build in the arbitration clause to where you have to show up in California if you live in Florida. So you have to go to them. Then when you get there, out walks a person or two people that the company themselves has on the payroll. And they sit there and listen to your case, and you say, look, they stole $25,000 from me. Oh, well, gee, we're sorry. We don't think you've proven your case. Here's $1,000. Now go your way. And when you try to appeal that, the chances of ever really succeeding on appeal are almost zero. Not quite zero, but almost zero.
Yep.
Did I get that right?
Exactly. Also, you notice that 16 attorneys general from around the states wrote to the Consumer Finance Protection Bureau warning that unlawful business practices flourish when class actions are banned. And the Consumer Financial Protection Bureau tried to outline rules to prevent this from happening. Chamber of Commerce immediately stepped in, pulled their puppet strings on their congressmen that they own, and they stopped it completely. So it's just done away with it.
Where's this going? Does it go to personal injury next, or at least is there a firewall up with people who are physically injured by the malice of a company?
It has absolutely gone to personal injury already. Right now, there are shields from liability for obstetric practices. Can you imagine that? If you go to a doctor who delivers a child, and as a result of his negligence you have brain damage to that child for life, then you've got to go to arbitration for somebody that they choose to do the arbitration, a hand-picked arbitrator, and their word is final. There are thousands of cases right now of fraud, wrongful death, even rape cases where people have lost the right to trial by jury because they signed a piece of paper. They didn't see the arbitration clause. They didn't understand the arbitration clause. And then they end up with arbitration.
And this Supreme Court continues to make that even worse and worse for the consumer.
There's one more last thing, Pap. They even have Christian arbitration. Some organizations are requiring consumers and employees to go to Christian arbitration where proceedings can incorporate prayer and the arbitrators can consider biblical scriptures in deciding their case. So guess which party's backing that?
We have fallen so far since Ronald Reagan first made his war on decency and common sense. Thanks for joining me, okay?
My pleasure, Pap.